such a good day to start with a mug of milk. Sweet and fresh, just the way I like it. Like the other days of online learning, I will turn on my laptop to check if there is any new news. Hey guys, we just got a new assignment. Yeah, we need to make a video on NTC injunction. Oh, I remember this topic being taught in the early semester. Let me reply to this. That is cool, let's do it. Firstly, we need to know what is anti-suit injunction. It is actually a court order to restrain another party from commencing a legal action in another jurisdiction. Let's see the purpose of anti-suit injunction, which are, firstly, to prevent the activity of forum shopping, where a plaintiff with a choice of jurisdictions chooses a forum reasonably in favor of his case. And secondly, it is to prevent a party from proceeding with duplicative litigation in a second court. To understand about this, let's see some illustration. The first situation is when a country is the forum of the case, and the second one is when a country is an alternative forum of the case. Let's see when the country is the forum of the case first. This is Mr. Ali. He is a designer and he lives in Malaysia. This is Mr. Muthu. He sells high-quality silk and lives in India. In 2019, just before the pandemic, Mr. Ali and Mr. Muthu entered into an agreement for the supply of silk to Mr. Ali. The contract was signed in Malaysia. The fabrics were shipped from India to Malaysia, and Mr. Ali used those fabrics to create his designer clothes. Subsequently, when the pandemic occurred, he got no orders. Thus, his business was not successful and his company was liquidated. Mr. Ali could not pay Mr. Muthu. Mr. Muthu then brought a legal action in India to claim for unpaid money from Mr. Ali. Mr. Ali, on the other hand, brought the case to Malaysian court for an anti-suit injunction to prevent Mr. Muthu from proceeding with the legal action. As a result, Malaysian courts won't be able to grant an anti-suit injunction because it will not be vexatious or oppressive to the defendant to bring a claim in a foreign court. Moreover, the plaintiff's company is in Malaysia. The defendant won't be able to claim the money from Mr. Ali, and the cause of action arose in Malaysia. Therefore, there was a stronger connection for the case to be brought in Malaysia rather than in India. The Malaysian court won't be able to grant the anti-suit injunction to prevent the defendant from commencing his legal action in a foreign court. In a single foreign case, it must be established that there is a connection with the forum of the country. Besides that, it has to be shown that there would be injustice to the defendant if the claimant was allowed to pursue the foreign proceedings. Since the court is ultimately concerned with the ends of justice, account must also be taken of the claimant's position. This can be referred to the case of FNI Aerospatiale and Lee Kui Chak and another, where it stated that the court will not grant an injunction if, by doing so, it will deprive the plaintiff of advantages in the foreign forum of which it would be unjust to deprive him. Not only that, the Midland Bank case also suggests to involve consideration on the extent to which the relevant transactions are connected with the English jurisdiction. This is from Judge Wilkes' statement of principle, which he explained to involve consideration of the question whether an injunction is required to protect the policies of the English forum. That is for the first situation. Now, let's move to the second situation, which is when a country is an alternative forum of case. This is a lorry driven by Ali on his way back from Bentong. While driving, there were big rocks blocking the road. He tried to push the brake pedal, but unfortunately, the brake was not working. Thus, he failed to stop his lorry and crashed onto the rocks. Subsequently, he died from that terrible accident. For your information, Ali was a Malaysian citizen working for Movit Sdn Bhd, which is a Singaporean courier company based in Malaysia. Movit Sdn Bhd claimed that the lorry was newly bought from Singaporean company called No Mercy, which is a well-known lorry manufacturer. However, upon inspection, it was found out that the lorry was missing several important components. Dissatisfied by the reaction of the companies, Movit Sdn Bhd and No Mercy were brought to the court by Aminah, the mother of the deceased. Aminah was prompted to take an action against Movit Sdn Bhd and No Mercy in both Malaysian and Singaporean courts. In response, No Mercy and Movit proceeded to claim injunction in Malaysian court to stop the proceedings in Singapore. In considering the anti-suit injunction, the court can only restrain the plaintiff from pursuing proceedings in the foreign court if such pursuit would be vexatious or oppressive. This can be referred back to the case of FNI Aerospatiale and Lee Kui Chak. Here, the determination of vexatiousness and oppressiveness were as followed. Firstly, it depends on the facts of each case. Secondly, courts may consider, firstly, the committee. Secondly, the party's interest. Thirdly, the dispute connection with the alternative forums. And fourth, caution when restraining foreign proceedings. Not only that, it is worth noting that the court will not grant an injunction if the restraint will deprive the plaintiff of advantages in the foreign forum, which would be unjust. Therefore, in this case, the Malaysian court may grant the injunction to No Mercy and move it Supreme Berhad to stop the proceeding in Singapore by considering the factors of oppressiveness and vexatiousness to the defendants. Besides, the court may consider the double actions of the same claims and the closeness to the Malaysian forum as the actions occurs in Malaysia. The witness is also in Malaysia and the company is based in Malaysia. Therefore, Malaysian court may grant an anti-suit injunction due to the close connection to Malaysian forum. That is all for the second situation and for this video. Thank you for watching and see you next time. Bye bye!